Marriage is a concept that has been around for almost as long as human civilization, and though it follows the same premise of uniting two people together in some way, how it is performed and regulated changes by country and by culture. As an American, I see marriage as a love match, with the only way to divorce as through the courts as the normal. However, there are many other places that see marriage much differently and would consider the American way as unfamiliar as we see theirs. Hi, my name is Megan Darveau, and today we'll be talking about Indian Muslim marriages, law, and divorce, and all its complex surroundings as a part of the World Ethnography Project. In the United States, divorce is a state issue. As the American system is set up, religious forums have no power to legally create a separation and split up a couple. Though this may seem normal to us, this is not the case in many other places, one of which is India. In Catherine Lemon's 2019 ethnography, Divorcing Traditions, Islamic Marriage Law and the Making of Indian Secularism, she describes the complex interactions between the religious and state authorities, with a specific focus on the adjudication of divorce proceedings. Within her book, she attempts to describe the full situation of Indian legal pluralism and Indian secularism as the intersections between the various marriage adjudication forums available, meaning how the state recognizes religious authority and to what extent and what effects they interfere with or try to regulate on their own. As a professor of anthropology at McGill University, Lemons focuses on the themes of gender, religion, kinship, and law to create full understanding of the minority politics in India and the secular distinction of religious authority. In her research in Delhi, India, from 2006 to 2013, she explored four separate forums available for use for Muslims in India, all in the first chapter, Lemons lays out the differences between what she considers to be the differences between the US and India when it comes to secularism. In America, we see it as a complete separation of church and state, but in India, it is completely normal for religious authorities to operate within and outside Indian law. The thing is, though the US may be extremely varied when it comes to cultures and beliefs, these don't really seep into law except for the majority Christian influence. As you can see, there are many different ethnic groups present within India's borders. In India, they acknowledge the vast amounts of languages, cultures, and religions by recognizing two separate types of law. There is personal law, which is where they would place family, marriage, divorce, and other similar issues, as well as their criminal law code. The criminal law code functions pretty similarly to what we would find familiar, but the personal law code is extremely complicated and debated. In an effort to recognize the cultural and religious differences between all of India's groups, they created this distinction to allow each religion and culture to follow their own religious laws instead of trying to find compromises between everyone. In this book, Indian Muslims are the focus, but this legal plurality and secularism also applies to Hindus, Buddhists, and all the other groups present within India's borders. Though the state courts still have legally binding power, as we will discuss later, this allows many other forums to hold power and give judgments that are simultaneously part of the legal system and also not affiliated. Once we discuss the various forums that are available to Muslims in India, we will come back and discuss more in depth how this system functions. In the second chapter, Lemons dives into the first of the four forums that will be discussed. I think that this one in particular was the most interesting of the forums, since it is run and controlled by women and women only. These places are called Manila Panchayats, Manila meaning women's, and Panchayat meaning local council. What I find interesting about these councils is that women are called in to defend themselves from male relatives. In many portrayals of divorce cases in the Islamic faith, it is discussed that the women have no power and are completely controlled by their husbands, so it is interesting to see a place that goes directly against what many assume to be the case. These women's councils, however, do not claim to be a religious authority, like some of the other forums we will discuss later. They choose to deal with cases that focus on economic precarity, domestic violence, and other women's issues, and function more as a mediator rather than an authority. They want to ensure the well being of the women they help, whether that means mediating a solution and the marriage continues, or recommending them a separation. These are also places of expanding women's entitlements, so they are not only preventing violence towards the women they serve, but ensuring that they are being taken care of, well fed, clothed, and emotionally healthy. Lemons also discusses that since many of these issues are seen as family issues, many families will not go to the police to handle the situation, even in cases of violence. So these Manila panchayats fall in a middle ground that women are more willing to go to. In Chapter 3, we finally get into more of the formal authorities that exist in India. Here we see how a qazi functions and the level of authority that he holds. A qazi is a judge within Sharia law. They function in what is called a dur ul qaza, or the religious court system within Islam. In this place, it is more about fact finding and handing out judgments, unlike the women's advocation we talked about before. Though the qazi's judgments are not legally binding in Indian legal code, they are considered binding within the Islamic religion and are treated as such by those involved in the cases, even though the qazis have no enforcement methods available. Lemons describes the qazi's cases as mostly divorce proceedings, with some other cases mixed in. These cases can vary, but almost always it includes one party attempting to divorce the other and one trying to keep the marriage intact. These cases are more formal, and each type of divorce has a specific name with specific consequences. There are four types, and I will put up a chart that will help distinguish the differences. Fax and Khul are initiated by the wife, and the difference between whether it is an annulment or divorce is the goal. And this decides what property and money is owed and required of each party. Talaq and rukhsati are initiated by the husband. The talaq is a divorce method which will be discussed later, and the rukhsati results in the wife's return to the marriage. These petitions and distinctions are important because of the emphasis on gender norms in the marriage and spousal obligation. In Islamic marriages in India, there is often still a mar, or dowry, as well as other gifts and property given on the occasion of a marriage. Depending on the category that the divorce falls in, determines if these have to be given back or kept by the receiving party. In these cases, as fitting with its bureaucratic nature, proof must be offered of violence or neglect for a divorce to be given, as well as proof that the woman stuck out the situation to the best of her ability, which is representative again of the gender norms in India as well as Islam. Chapter 4 continues the discussions of the last chapter and how the Dural clauses fit into the Indian legal system. Lemons describes how many see these divisions as a practical division of labor and that the state courts handle one thing and the Sharia courts handle another, so neither gets overwhelmed. This interaction between the courts has also changed as India's colonial status has, and shows the differences in the amount of meddling, shall we say, that the state does in the religious courts. Lemons discusses how in 1939 the Dissolution of Muslim Marriages Act, also called DMMA, was passed, and it was one of the first instances of the state interfering in Sharia courts. This law expanded a Muslim woman's right to get a divorce under certain circumstances, such as abandonment, financial neglect, impotence, and a variety of other issues that a husband could have. This is one step in the law code that regulates the religious courts without inviting them fully into the system. It also legitimizes the religious courts in a way that had never been written before. It mostly shows the interest of the Indian government in families and their doings without also wanting to fully get involved. It also sets up the boundaries of personal law and shows that the state is willing to get involved if they believe that the religious courts are not serving their people well. The problem with many of these state legislations is that many are inconsistent and often do not make any sense when compared to previous rulings. Lemon also talks about how Muslim women can tend to be, as she says, savvy with their options. They make use of the variety of options to try and get the result that they desire. If the Dar al Qaza doesn't give her the result she wants, she can try to use the state courts. This is where legal pluralism, I think, is the easiest to understand, because there are a multitude of forums that are available that all do slightly different things and can offer different results, but also belong to the same system. Chapter 5 begins discussion on a new forum once again. This time we are discussing the role of muftis and their fatwas in Muslim divorce. Muftis are thoroughly trained religious scholars that communicate through written exchanges rather than court cases. Similarly to the qazis, their decisions have no legal teeth to enforce them, but are again highly respected and followed as closely as possible. The qazi gives judgments that enforce marriage as a solution to divorce and focus on the economics of the case. Muftis are more concerned with the exact religious writings and followings of the cases. They deal with less cut and dry cases than the courts do, and it often comes down to the exact wording of passages in the Quran. These decisions are given through what are called fatwas. Fatwas are usually short and to the point and given as a direct response to the question that is asked. This chapter mostly discusses fatwas in response to the triple talaq. In Islam, a husband, but not a wife, can say talaq 3 times and the marriage is considered ended. This is held in high importance, and there are many hoops to jump through if the husband would wish to continue the marriage after the triple talaq is said. In most of the questions that the Mufti received, there is a question if the talaq was carried out correctly and if the couple is indeed divorced, and if they are divorced, how the property should be split up and what is required of the husband in taking care of his now ex wife. All of this depends on the exact wording and tense of the talaq. In India's, the state courts tend to not like the talaq since it is hard to regulate as it is a verbal method instead of on paper. This shows the complication of the system because even if the state does not recognize the triple talaq, the Mufti does, and so they are divorced by Sharia law even if they are not, according to state law. Lemon's final chapter addresses another responsibility of the Mufti. Along with the Mufti's job in giving religious advice to some of the more complicated divorce cases, he also helps find more spiritual solutions to other marital issues that come before a potential divorce. In these cases, Lemons tells of the Mufti as a counselor who is looking for the best solution. Many times, there is not a religious question specifically, but simply a family matter to be solved, and he keeps records of family troubles to better keep track of histories to give better advice down the road. In these cases, the Mufti is more trying to heal the parties involved spiritually to prevent divorces before they even become an issue. Lemons describes it as using legal terminology with actual cases, but also falling in the in between religion and law. In the conclusion of the book, Lemons describes how everything she has talked about in the book shows the vast system of support and the many forums that Indian Muslims can go to for help. Even though slightly different in purpose and methodology, all of it is there to guide its people to the best solution. In these traditions, the state has attempted to regulate and offer some legal ruling, but it has been inconsistent and less revered than the religious authorities that have existed there for centuries. And each has its own power, and it is interesting to try and detangle the interactions and sort out who specifically does what. These interactions and intersections are what make up Indian secularism, which is again practical more than a conceptual idea. And divorce is central to all of it because of how many arenas it is involved in. Divorce within this system shows the influence of kin on a relationship as well as the issues of gender inequality that still exist today, which Lemons wants to be the main thing that comes out of her ethnography. I have two passages that I want to read from the book that I think show the full spectrum of support that can be received from these various forums. The first comes in the first couple of pages and reads as follows. The Kazi and I both looked up when the woman entered, and he asked what she needed. The woman, who wore a tired black burqa indicating her membership in a pious but poor family, respectfully asked the Kazi to open a divorce case on behalf of her daughter, whose husband was allegedly abusing her. The Kazi took out a form with the title printed in Urdu at the top of the page, Darkwas Dene Ka form, or a complaint form. The form noted the name of the Dar ul Qaza they were located in and also provided space for a case number, the name of the complainant and respondent, their parents, and their full addresses, including the post office, police office, and the district they were in. The last printed line of the header read, Guzarish hai ki, a phrase in Persianate Urdu unused in everyday conversation, followed by an expansive blank page. The woman looked at the form and told the Kazi she was unable to read or write. The Kazi replied that she should take it with her, have someone else write down the complaint, and return it with the completed form. She returned a week later with her daughter and handed the Kazi the form completed in the Devanagari script in which Hindu is written. The Kazi impatiently returned the form to her, insistent that it be presented to him in Urdu, the language that the Muslim clergy in India are trained in and in which they write. The morning the woman left the Jor al Qaza for the second time, she appeared disheartened and frustrated that the Kazi would neither read her form completed in Hindi nor examine her daughter's bruises, the latter of which were material evidence of ongoing spousal abuse. For this woman, providing written material in Urdu appeared to have been too steep a condition for entry to the Dar ul Qaza, or perhaps she found that the Kazi's gruff manner did not bode well for her daughter's case. Either she and her daughter did not return to have a divorce occasioned. However, even though this woman did not end up initiating a case in this Dar al Qaza, her decision to approach the Qazi is revealing. It indicated that the family disputes among Indian Muslims can be dealt with by consulting a religious legal scholar rather than by bringing a case in the state courts or registering a complaint with the police, and her hesitation to approach even the Qazi also reflects the difficulty people have in taking marital disputes to an outside party. The second excerpt is from the final chapter. On an afternoon in June 2013, a young woman approached the Mufti looking distraught. She told him that she had come seeking a taweez for her husband because although he had back trouble, he insisted on playing cricket, and she wanted him to stop. As she and the Mufti talked, it became clear that she was also worked up because while her husband was playing cricket, his older brother was busy taking over the family business. She was beside herself with anger because instead of helping her to reason with her husband and convince him to put more of his energies into the business, her mother in law was encouraging his pursuit of cricket. Because of this situation, the woman was often bitterly angry with life and with her in laws, and life with her in laws had become increasingly frustrating. The taweez that the Mufti wrote did not address the woman's husband or her in laws, but instead he wrote one to give the petitioner advice to have patience and to diminish her anger. The Mufti had known her family for some time, and he therefore knew that it was true that the mother in law did not want her younger son to take over the family business. I pick these passages because they show that even within the system, there are a variety of responses that are possible. The first had a cold reception with no solution, and the second with warm regard and care with previous knowledge of the family. With the first, we see how even with the extra forums available, some people are not able to get help, and it shows that the system is not perfect. I also liked how it shows that these forums, though discussed mostly in how they separate families, are also trying to resolve problems and keep them together, at least in the case of the second passage. I thought that this was a very interesting book, and it covered a topic that I really had no idea even existed. Before this book, I was not aware that other countries had competing and parallel court systems because I'm so used to how the US does things here. It really was eye opening to see how differently things can be done and how different the priorities are for other cultures. I really appreciated that with each forum, I felt I got a complete understanding, or at least as much as I could without actually experiencing it, and it was not one sided. She talked about how each forum was good and bad, and how it helped and hurt specifically women seeking a way out of troubled times. The one big criticism I have about this book is that the terminology and writing was so thick in some places that I had to read it 3 or 4 times to understand what she was trying to say to me. Especially in the legal and Islamic terminology, a glossary or cheat sheet of terms would have been helpful for those that have little experience or knowledge of Islam, India, or even law going into this book as I did. I did very much enjoy it overall, and I really liked how she continually mentioned specific and personal stories, because even though everyone involved in the book is a world away from me, I felt like I could relate to them and I could get a feel for how they felt on the topics at hand, along with their frustrations and joys. So, this is the end of my project, and I hope you guys learned something just like I did. Thanks for listening.